Okay, good morning, everybody, and thanks for coming at this early hour on the third day of this conference. Bernardino and Philip today will be talking about basically how you manage litigation risk. Both of them are senior in-house attorneys with a lot of experience handling litigation and contracts on a worldwide basis. And they're going to talk to us today about the importance of understanding where your liabilities are, where your potential lawsuits are coming from, what type of lawsuits you may be faced with, and how best to structure your approach to the potential risks. Because it's different, whether you're dealing with contractual partners, perhaps you're dealing mostly with arbitration, then you will do something. If you're dealing with mostly court cases in various jurisdictions around the world, your approach and your way of managing those cases is going to be completely different. So they are going to speak to you from their particular perspectives. Please ask questions. They have got lots of experience and they're willing to share this experience. So I think let's get started right now. Philip, do you want to get started?
Sure. Thank you, John, and thanks for the introduction.
Maybe say a little bit about your company as well.
Yeah, sure, I'll do that. Yeah, I just wanted to suggest that. So, well, my name is Philip Schmidt. I work as a senior legal counsel at Zimmer Biomet. Probably most of you are not aware what kind of company that is, but it's kind of a world leader in orthopedic implants, so knees, hips, and all other extremities. Well, we help a lot of patients around the world to, move better, have less pain, etc. Where do the lawyers come in this equation? Well, on the one hand side, we have typical in-house type of work, contractual work, deals, etc. But then there's, of course, an element of litigation as well. And, typical litigation that John just mentioned, disputes with distributors or commercial partners, etc. But one other element, which is maybe a bit more specific for an industry where the product, as in our case, is sold to an entity which uses the product, but it was not the ultimate end user of the product. So we have surgeons implanting our products into patients, but patients are not our contractual partners, obviously, but patients are the ones who need to deal with that product. And, if you implant millions of products, of course, it's bound to happen. In some cases, there might be some issues with these products, and that may lead to litigation. For us, very relevant is obviously the Product Liability Directive of the European Union, and the various implementing acts around the countries around Europe and EMEA countries. So that's, I think, another source of litigation which we take care of quite a lot in our everyday practice, where we deal directly with patients who before that never had any contact with the company, maybe didn't even know the company.
Before moving on. Okay, press for 3 seconds. Before moving on to Bernardino, let me ask you a couple of questions, Philip. First of all, are you faced with many class action suits in Europe with respect to your products, or is it mostly single court cases?
Thanks, that's an excellent question. And I would say yes and no. So it depends on the jurisdiction. We know, for example, from the UK, they really have a class action type of litigation regime, those group litigation orders. And we faced class actions in that jurisdiction. Having said that, in many other jurisdictions, at least in the past, this tool didn't exist or was very ineffective. We have in Germany, etc. There was room for class action, at least from a legal perspective. But I don't think it was a very effective tool. But now, of course, we have the collective redress directive coming up, and which is in force and which should be implemented in the various member countries in the European Union, which for us is, of course, let's say a source of concern, and we expect that we will see more class action type of litigation, because I think the nature of our products, because it's a fairly standardized product implanted in a lot of people, would lend itself to typical class action type of litigation. But we will have to see how that plays out. I think it depends on the jurisdiction, depends also on the style of doing litigation in different jurisdictions and the litigiousness of the participants.
And now let me go to one of my favorite questions. Again, for those of you who don't know it, the World Bank puts out an annual survey basically enforcing contracts around the world, which looks at the efficacy of various legal systems, actually legal systems in all countries around the world, and for the larger countries actually looking at various individual locales, specific localities within those countries. So they look at the time of litigation, the cost of litigation, and actually they even come up with a value judgment regarding the how good of a judgment, how good of a legal process it is. So my question for you, Philip, is you handle cases basically around Europe, the Middle East, and Asia as well, or Africa?
Not Asia, Africa.
Okay. Could you describe some of the variations in terms of time, cost, and likely outcomes in the countries in which you work?
Sure, I'll try. Well, okay, that's a pretty all-encompassing question, but yeah, I'll try to break it down. And I think one distinction we need to make is between, let's say, what I would call commercial matters, so contractual disputes, etc., and then this more redress type of litigation, meaning typical product liability claims. I'll start with the product liability claims. So this is really a thing which is handled jurisdiction by jurisdiction, very individual cases. There might be potential for class action type of litigation, something we haven't seen as much in the past, might be more in the future. But there really it depends a lot on the jurisdiction, but also on the individual court and judges in our experience. I mean, I would have typically thought before doing this job that, for example, Germany would be a pretty efficient country for doing litigation. But I can tell you we have cases which have been pending, in first instance for 8 years, which is, not only a problem, I think, from a rule of law perspective, but also an insult to the patient, regardless of whether that's our counterparty, but they should have a possibility of either getting some redress or at least some closure of these cases. And some of these cases have been pending for years and years and years, just due to understaffing. A huge issue is finding proper experts, scientific experts, to look at very, very complex scientific questions, medical questions. And it's very difficult to find these people because either the experts are not qualified, or if they're qualified, they're most likely biased because they work with the industry. So that's a major issue which makes litigation take a long, long time, even in jurisdictions where you would think it would be quicker. Having said that, I mean, yeah, I mean, I don't want to call out individual countries, but we've experienced delays in Italy, for example, in Spain. Germany has been more of a surprise to me. I have to be honest. Switzerland tends to work quite well. The countries in Scandinavia are pretty efficient because they have typically kind of an alternative dispute resolution mechanism in these matters. They work with these so-called patient ombudsmen, and many of those disputes get resolved before actually going to court. So that's pretty efficient. From a commercial side, I think the UK stands out as a extremely expensive market to litigate in. So you're very, very motivated to settle. Yeah, and other civil law countries, I think it boils again down to expert evidence. You know, in many of these countries, the court will appoint an expert who is an expert or is not, and that will really, your success in litigation will pivot upon that and upon the quality of this expert, and that can be difficult, to say the least. And maybe alternative dispute resolution mechanisms or arbitration could work better.
Okay, thank you very much, Philip. Let's move to Berardino right now. Berardino, thank you for coming. Perhaps you can start off by explaining what your company does, your role within the company, and then move on to what type of disputes you get involved in and how those are managed.
Okay, thank you, John. Yes, my name is Berardino Tizzani. I have almost 10 years experience in litigation in Italy as a lawyer, mostly with oil and gas company. But in the last year, I'm working for a company here in Breda that is specialized in cold logistic. I'm the the legal counsel contract management, and I take care of the construction of this warehouse around the world, mostly Europe, Asia, and Australia. Based on my experience, I have to say, many different litigation and many different reasons why a litigation can arise. Can be for everything. A litigation can be really everything. Can be an employment unfaithful, can be an accident, can be a mistake, someone forgetting something, a proceedings or a term, can be a customer not paying. When we see what can be the risk of a litigation, we have to understand that is endless. We have infinite possibilities that a litigation can arise. And this is why probably me and Philip work in a company, because we are probably the first step to reduce a litigation. What is our job? It's not to be lucky. Our job is to pay attention, to understand our business, to understand what is the criticism in our business, and try to reduce the window of litigation risk. Of course, our world is not perfect. We do an intellectual activity that is not a mathematics science. We cannot do 2 + 2 is 4, but at least we can try to get close to 4. We can try to reduce cost, to reduce damages risk, reputation risk. We know that there is a Dutch company having a class action this year, and the impact on the stock market that they're receiving is huge. Almost lost half of its value on the stock market. So a litigation for everything can happen, can have very huge consequences. In my specific role today, I mostly deal with construction company, and particularly, let's say that my biggest counterpart is a general contractor for a 50-60 million project with 1 year length. You can imagine that if you have 100 people working on a site for a huge project with 20 other subcontractor or specialist contractor on the same site, the risk of litigation is very high. And what is very complicated in this type of role is standardization, because of course we are a Dutch company, we like to think as a Dutch company, but then we work in Spain, in France, in Italy, in UK, in Malaysia, in Australia, and you cannot have the same approach in all the country, because for many reasons, every country is different, but in the same time, you don't have the same risk. Country act differently, law act differently, legal counsel or legal lawyers give you different advice. Trust me, I can show you the same contract reviewed by a lawyer in different country, all of them will comment something different, and all of them are on opinion or experience, what is more risky than something else. So what is litigation? Is a very interesting, complicated fact to resolve and to mitigate, because the consequences are very high and the cost can be much more than the investment to reduce this risk.
Berardino, in the contracts you are negotiating now, your dispute resolution clauses, first of all, are they heavily negotiated? And second of all, what are your preferences? Do you prefer local courts? Do you prefer arbitration? Does it depend on the jurisdiction?
I will say the first it depends from the counterpart. It might depend the sites, it might depend the location, where is located the company, and it also be that it depends from the country where the project is developed. Let's say that everybody, of course, like the first part of this clause, the one that the party will solve the claim, the litigation amicably, friendly. Everybody like this, and I saw that bigger is the company, big this is appreciated, because companies, as we say, don't like litigation. So in the moment that a claim arises, many companies prefer to pay instead to face a claim. Of course, the claim needs some ground, some justification, or at least a balance between cost and convenience. Secondly, a big company usually loves arbitration clause. They provide guarantees, particularly if you work worldwide. Globally, provide you guarantee that are speed, are sure you can hire a judge, an arbitrator that has experience in the same field, and it can speed up the process. But in the same time, for example, as Philip mentioned, there are some very efficient countries like Germany, where maybe the local lawyer will say your arbitration is too expensive. A court is much cheaper and efficient, don't worry. In Italy, if I would invest 55, 60 million, I will go to arbitration, for example. I don't want to face a 10-year claim for damages or something similar, very complicated. And it's fun about litigation and jurisdiction, because if we mention about efficiency of the country, I know how many of you know that, for example, Italy has been chosen by international lawyers to delay process around the world. Because the judge in Italy, if you start a claim, if you file a claim, will not decide about jurisdiction in the first claim, in the first hearings, in the first instance. He will decide in the end. So I can do a process for 3 years, and then the judge in the end will say, sorry, I'm not competent. You should go to UK. This is, this is why you prefer arbitration, and why maybe some country avoid to go to court.
Why don't I open it up a little bit for questions, if there are any questions from the audience? Does anybody want to ask Berardino or Philip what they think or how they handle specific questions? No questions, everybody's still sleeping. Go ahead. We've got somebody over here. Right behind you.
I wonder whether you have the experience like I have, that sometimes you get hit pretty hard by arbitration, and then management says, no arbitration anywhere, we go to the courts. Then you get hit by the courts very hardly, and say, go back to arbitration. So I've seen swings here. Do you see swings as well in your company?
Yes, it's a kind of swing. Managed from, it depends to who you ask. Depend on the background they have. I would say that in my department of legal, we mostly prefer arbitration. Then if you ask to some others, maybe finance department, or procurement, or engineering, they really don't care. So when you give them a brief summary of what is what, they will say, no, let's go to a court. I believe justice. But, but people sometimes forget that justice is blind, but the judge not. So, court, I think, is very risky, and I'm really against this swing between arbitration and court, unless I don't have a local opinion from a lawyer that really provide me good motivation why court will be better than arbitration.
And maybe to add a counter perspective to that, I mean, I agree. I'm sure there are certain swings, you know, but it's probably a bit more of a longer term trend. And again, as you say, depending who you ask, they have a different opinion. I mean, I can say from my experience in our company, we seem to prefer the court solution rather than the arbitration solution, just for the simple fact that apparently we've been lucky enough on the commercial side to not have too much litigation. Apparently, we managed to either settle or just amicably resolve our disputes with our commercial partners. Having said that, we of course have the other side, the product liability related side, which is not controllable for us. We cannot enter into arbitration with a patient. This is going to be state courts, and it's something we deal with, on a continuous basis. And so I feel that senior management is pretty used to and probably comfortable with a court solution, at least on that side. So yeah, but it might change as well, and it depends on the jurisdiction. I think if you have a jurisdiction which is unreliable and expensive, you will definitely want to go for an arbitration solution.
If you don't mind, I'm actually going to try to say a few words about this subject too, because as an arbitrator, I was involved in 2 arbitrations where, despite signing contracts with arbitration clauses, the claimants actually fought very, very hard to have the cases heard in local courts, largely on the basis that they thought they would find a more receptive audience with either the local judge in the first case, which was in France, or with the local jury, which was the case with the second case. In the one dealing with France, it was actually quite interesting. It was actually litigated for almost 7 years before it went to arbitration, before the Cour de Cassation, the highest court in France, said, you guys have to arbitrate this. And then it came to me as an arbitrator. I made my decision, and one of the important elements in this case was that, having litigated this case for 7 years in the local French courts, the winning party had actually spent a great deal of money in lawyer fees, which were only very minimally compensated by the French courts. So in my award, I actually awarded legal fees as a part of the breach of contract claim for the winning party. And of course, the losing party, who liked litigating in French courts, went to court again to challenge the award and have it set aside. And the Paris Court of Appeals actually ended up affirming my award, and basically acknowledging that an award could award lawyer fees or attorney fees for litigation that preceded the arbitration. So it was an interesting case, but it goes to show you that even when you have contracts, there will be people who want to move it into courts, and those efforts may or may not be successful. Go ahead.
I have a question. So, as you know, the arbitration is based on expertise.
Wait.
So the question is, as you know, the arbitration is based on the expertise. So in your opinion, what is the ideal method or criteria for choosing those expertise? Thank you.
Again, it depends on the specific case and technique. Can be everything. Can be a university professor with expertise in that topic. Can be someone that write articles about that topic, or someone that with a tracked experience in the same cases. Today, actually, we are lucky because we live in a world where we can find a lot of information with a click. I think that probably 20 years ago, to find an expert in arbitration was much more complicated. Today is easier. You can make arbitration online. You can find arbitration with expertise all around the world for your specific case. You can drive the arbitration in English. All of these 20 or probably 30 years, maybe someone knows better than me, but I believe that we are living in a world that, from this point of view, is helping the business, is really, really helping the business, because facilitate the possibility to find expert in very tiny field, using different criteria, or the criteria that better fit for the specific claim or company. So I think today you can even do a selection price, the price probably of the arbitration, I believe.
Yeah, maybe to add to this point, I mean, I agree that we have as much information at our fingertips as ever, probably in world history. But, and interestingly enough, I mean, I've made that experience, depending on the field and the more you go into detail, you actually end up maybe having one or two potential experts, which then is no real choice at all, right? And it might also be that these people are capable or can handle this case on paper, but then coming down to the real business of it, it just doesn't work. I mean, one experience we've had was that we could identify professors, scientific or members of the scientific community who were really specialists in specific chemical questions, but the dispute was pivoting upon manufacturing techniques. So it was not only knowing about the specific chemistry surrounded by that, but also the actual manufacturing on a large scale capabilities, and that we learned is an entirely different set of skills. And just because someone is a professor in chemistry does not necessarily make them a specialist in how you produce a certain compound on a large scale. And that's something I think the more you go into detail and the more specific the question is, you might end up with maybe one person worldwide, or one person who is actually willing to act as an expert. So, yeah.
Philip raises an interesting, actually a very important question. Is it, as when you get into complicated issues, dealing with medical devices, dealing with, right now you made me think about a case I had actually a while ago in which I was helping an Italian manufacturer of high quality steel products. They made huge bolts, which were used in very big scaffolding projects for ship repairs. There was an accident and the bolt actually ended up breaking, but finding the proper metallurgical expert to testify that the bolt actually was of high quality and its rupture was due to matters beyond the tensile strength of the steel was not easy. And the other thing is you want an expert who's not only accepted, but who can write, and depending on the jurisdiction, particularly in the US, who can actually stand up in court and make an intelligent presentation that is understandable perhaps to a jury. So it's not easy finding experts to deal with the particular case that you may have.
Hi, thank you.
Maybe if you could introduce yourself too.
Oh, I'm India Bodine, and I am a plaintiff's class action employment lawyer from Seattle, Washington. And so this is going to be a very basic question, and I apologize for that because I'm learning a lot more about the European ways during this forum. And so my question regards discovery, which is, it seems that there is a very big difference between the jurisdictions where I practice and Europe and parts of Asia. I'm aware of Japan and other places where there is no discovery mechanism similar to the United States. But when I bring a case, the discovery process is a huge part of the case. For example, when you're analyzing risk, I assume on the other side, on the defense side, you're going to think, oh my gosh, there's leverage in settling early. There's the benefit of costs and time and everything like that goes into thinking about how discovery is going to play a role. And it sounds like in a lot of the European jurisdictions, and of course, correct me if I'm wrong, this mechanism is not similar. And so I'm wondering, at the outset of a case, in analyzing risk, do you have everything in front of you to analyze merits and damages? So then, when you actually are defending it or bringing it, you kind of have your arms around everything. Or does discovery and at least investigation or some form of investigation into merits and damages play a role? And how does that pan out in terms of cost and time and the way that the courts, will allow you to do those investigations, I suppose.
Yeah. Yeah, this is really, really excellent question, and maybe, actually brings us back to the main question of this forum, right? And how do we analyze litigation risk within the organization? And maybe I'll go a bit on a tangent, but I'll get back to your actual question. So I think for us in the organization, I mean, there are several ways of reacting or analyzing litigation risk. I mean, one, you could probably distinguish between kind of a more proactive and a more reactive approach. Proactive more being, you get involved earlier, you look at robust contract templates, for example, internal policies, to avoid certain risks of data breaches or whatever. You might be looking at, training people in a specific kind of way. You might want to have some kind of compliance-related audits, these type of things, and that's all on a kind of more proactive side, right? Or even designing your products in a way, that they cause less issues. And then the other side is the more reactive side, where you might have an early warning system, like some type of compliance hotline or something where, people can ring the bell or, blow the whistle. Or you might be learning from former disputes, oh, this is something we didn't do very well. Okay, let's change our contract template or something like that. Now, when we come into litigation, I mean, obviously we do an analysis of the risk. In-house, we very often rely on our local counsel, our local external counsel for that. But since we don't have this wide discovery, and having said that, depending on the jurisdiction, we obviously have mechanism of getting certain documents, etc. You just have to make more specific requests to the counterparty rather than doing this large scale, just dump everything there like in the US. We tend to rely more, I think, on experts. So courts, they will demand of the claimant that they will present certain type of evidence in order to bolster their claim, obviously. Now, for example, just in our case, a patient, how do they prove that a product is defective? I mean, they don't have the expertise. They don't have any internal design documents or something like that. So typically what a court will do in a jurisdiction like Italy or like Germany, they will appoint an expert. And that's going to be a so-called independent expert. It's not appointed by the parties. It's not an armchair expert from the parties, but it's an expert appointed by the court. And that expert will request documents from the manufacturer. We'll get all of that background. We'll look at all of that and then, crown it with their expertise and ultimately come up with an opinion and say, like, look, in my opinion, this product caused this issue or these damages, and they might quantify damages as well. So it is a bit more of a, let's say, a kind of black box, which is less controllable by the defendant or even by the claimant. But of course, you will have your own experts, right? I mean, we will have our internal, let's say, research people who know the products intimately, who might have been able to do an analysis of the product which broke. And we will have our own opinion on that outcome, and we will always be able to argue these points, and that will inform us on how likely we feel that this claim is going to succeed or not. Yeah, I think it's probably based on different information, less document heavy, less of this smoking gun type of evidence, but more on a, let's say, slightly more objective sphere of, relying on experts, expert opinions. I don't know if you agree.
I agree. I want just to add to Philip two consideration. The first one is very important, the collection of information and the trust between inside the company and with the local lawyer. And this, I believe, in my expertise, and I talked with Philip he agree with me, we talked about this before. One of the biggest problem of the company is the conservation of documents, conversation of email. When people say, let's talk, is easier, quicker, we solve quickly, you lose information, you lose the agreement itself. And if something happened 2 months ago, easy. But if it happened 5 years ago, maybe the direct involved person doesn't work for the company anymore. And to collect what he thought, why he did it, can be very, very complicated. So to avoid the disclosure and to have a very full picture, a complete picture, inside is very important to have a good conservation, storage of the documents, of email, and a good track system to understand why has been taken that decision. A second, as Philip said, in our jurisdiction, civil law, we have a different system. For example, in Italy, you have 3 briefs. So every part for the first time say, this is my theory, each of them. And then the second brief is why the theory of the other one is wrong. And the third brief, you reply to the other 2 of before. So the disclosure in a certain way happen by step, and only on what the party decide to disclose and what the party decide to accuse to the other party or to blame the other party for. So it's a little bit different process. Our trial has mechanism to facilitate the disclosure of documents. Maybe not always happen, but for example, a judge can ask a company to provide a document if the other party proves that is an essential document to solve the litigation. As well, there are expertise, and this expertise can ask as well with the power of the judge to provide more document, to integrate the document. So we have some system. It's simply different. We don't provide all the information in the beginning, but we discover them during the trial. The complication of what has connected to the first point. You have a very short period to provide this document, because you should provide to your lawyer before the trial in order that he has a full picture and he doesn't have surprise at the first brief. Because when the first brief starts, you have only 45 days to provide all the proof and to reply and to make a good defense. So this is a little bit the system in Europe, because then if you don't provide documents on the first trial, in appeal you cannot provide new document unless you cannot prove that you didn't have the document back then or has been created later. So we have some mechanism.
Go ahead.
Good morning, my name is Dima Alexandra, Bulgarian qualified lawyer and mediator. I was wondering, do you consider multi-tier clauses when drafting contracts, and are they enforceable in your jurisdictions? I'm kind of aware of Switzerland that maybe courts take proceedings due to such clauses, but please correct me if I'm wrong.
Sorry, I didn't hear the beginning of the question. Could you
The
repeat it?
multi-tier clauses in the contracts envisioning amicable dispute resolution prior to any kind of adversary proceedings, either arbitration or litigation. So I mean negotiation or mediation. Do you draft such clauses, escalation clauses, or?
Okay, yeah. I think you mentioned that before, right? I think it's very typical to see some type of clause, which basically says, okay, we're going to try to resolve this dispute in an amicable way, and if that doesn't work, then we have another escalation stage, and then we go into litigation in state court or arbitration. Indeed.
In the contract?
Yeah. I think that's something that you typically see there, and then some type of mechanism. Okay, you have, say, 30 days or 90 days to resolve that, and if that doesn't work, then only then you can start proceedings.
Do you weave in as a second phase mediation? Because that's what we have been advocating in the Netherlands for companies to do. First, amicably try to resolve it up in the management level, not the lawyers. Then 30 days of mediation, failing which the most reasonable party can go to court. And that works well because it scares people off. It takes a little bit extra time because you need 30 days for mediation, but if you can't mediate in 30 days, the likelihood that you will be successful mediation is pretty slim. So that works. And so it's kind of four-step approach, conciliation on the management level, mediation, then court. Does that sound reasonable? I mean, would that be something you would like to weave in your contract because it doesn't cost you anything? I see that in-house lawyers fail to do that.
Yeah.
And then when in the process of a dispute, they come to the conclusion, hey, maybe we should mediate. It looks like that the party asking for mediation is the weaker party. When you have it in a contract, you cannot say they feel it's weak, they don't want to go to court, they want to mediate.
It's a good point. I mean, from my personal experience, I can say we don't have mediation clauses in our contracts. We might have these, 30-day dispute resolution kind of mechanism type of clauses, but specific mediation not. Where we encounter mediation quite often is that, in many jurisdictions this is an essential part of the proceedings. You need to engage in mediation, or at least try to engage into mediation before you can start that. My experience is it normally doesn't work, to be perfectly honest, because if it escalates to a litigation, typically you've talked with the other party before, and it's really the ultima ratio. But I don't know if you have a different experience.
I work for a Dutch company. I have your same approach. We have a fourth step is try to settle the dispute between the management or the legal counsel. Second, you do a mediation, 30, 60 days, no longer. And then if you cannot find a solution in mediation, you can go to court or arbitration. We have the same approach. And I have to say, from my point of view, from the company point of view, yes, it avoids claims. Because you already start to solve the matter in the first stage. The second stage is not expensive as an arbitration or a court, but already is giving you some direction. So, do you have enough proof? Are you a strong position or the weak position? And it's pretty short period of time. And then, yes, I agree with you. I think it's a useful approach, and we continue to use it, yes.
Further questions? Philip, before we close, I did have one question for you. You mentioned the collective action directive. Could you actually describe that for the group here to the best of your abilities? And Berardino, you can chime in as well.
Yeah, that would be excellent. Let's do that as a team effort. Now, so, well, the European Commission decided to come up with something called the Collective Redress Directive, where they essentially said we need to have a common approach across the European Union on how to address, class action litigation, because there's a phone ringing somewhere.
Yeah, he's in the back there.
Oh, okay, great. So the question was, okay, how do we harmonize that across the European Union? Because there were a lot of countries that already know something like a class action, more developed, say, for example, in the UK rather than in other countries. In Germany, you had something called, I think, eine Musterklage. But I think many of these schemes were, let's say, plagued with the issue that you had to have some kind of type of consumer organization or something that took on this case on behalf of all of the consumers. And it was cumbersome and difficult to do. So I mean, while it has been done, it wasn't the same as, say, in the US, where we have these typically. So then the European Commission set out to come up with these different standards on when to allow collective redress for consumers, who could actually bring those actions. There are these third parties that can bring those, who can finance those. And while the directive is in place, there's still, at least to my knowledge, a lot of insecurity in the different member countries on how that will actually be implemented, what will be allowed. Can you have third-party litigation financing, for example? Can you have these type of funds that provide pre-financing and then go for these large hitter class action type of litigation? There's also a question of can you go forum shopping among the different member countries, who might have a specifically beneficial regime on collective redress. I know the Netherlands have been floated around as a jurisdiction which would be probably quite beneficial for these type of class actions. Others not that much, but that remains to be seen how that actually will play out in the future. I don't know, Bernardino, you want to add something?
I was not aware of this. I can only simply one thing. I think it's a good implementation, a good news, because surprisingly, Italy was, for example, one of the countries that never integrate class action until 5 years ago. So I think it will help European community to protect European interests. So I'm optimistic.
Okay, are there any final questions for our panelists? Okay, with no final questions, I want to thank Philip Schmidt and Berardino Tizani for their presence here today, for their comments, and I think we've had an excellent start for the morning. We're going to have a quick coffee break, and please come back because the next session is on red flags and bribery and corruption, and we're going to have a very comprehensive presentation on how to bribe around the world. Thank you.